Good morning, and thanks to all of you for joining us. Welcome to Arnold & Porter's webinar, Bringing Employees Back to Work. We call this Reopening Your Business in a COVID-19 Environment, a discussion on protecting consumers and employees. And you'll find out why we call it a discussion as we go through the process. My name is Kathleen Wechter. I'm a counsel at Arnold & Porter in our New York office. And today I'm joined by my colleagues, Charlie Washstock, Josh Alloy, and Catherine Jeffroy. We'll try to get to questions if we have time. If not, you know how you can provide the questions. So today we're going to do an interactive program, a discussion, as the title suggests, on how to reopen your business in a COVID-19 environment. The hypotheticals and the questions we're focusing on involve a retail sort of environment because our thinking was that retail exemplified some of the toughest questions that any business would face. But whether you're primarily operating offices or you have warehouses and distribution facilities or manufacturing or food services as part of your business, the idea of a retail environment where customers are interacting with employees on a regular basis was, to our way of thinking, the best way to demonstrate some of the legal issues that businesses are facing today. And that's what we'll be discussing. Here you see our, next slide, please. Here you see our advertisement for our coronavirus task force. And this provides updates on various issues in a rapidly changing world. And if you'd like to subscribe to the mailing list, please contact any of our presenters and we'll add you to the list. We routinely update it for the changes of law, which, as you know, are happening very quickly. Next slide, please. My colleagues today are from different practice areas and offices in our firm. After me, next up will be Charlie Washstock, who works in the compensation and benefits practice here in New York. Charlie's been very active on the coronavirus task force and has worked on writing many of the updates. Next, Josh Alloy is a labor and employment lawyer in our Washington, D.C. office. And finally, Catherine Jeffroy in our Chicago office works in areas including compensation and employment issues. We have all been advising employers in New York State, New York City, and elsewhere on the rapidly changing landscape. Next slide, please. The overview of our discussion today is to talk in different hypotheticals. Next slide, please. And what we'll be focusing on is preventing exposures to COVID-19, the interplay with employment laws, and responding to exposures that may occur in the workplace. We'll go through each topic in more detail. As I mentioned, our goal today is not to give an overview of the law in general, although we'll talk about that, but rather to go through some real concrete facts to focus on the judgment calls that you and your businesses will need to make as reopening continues. And then also, since it looks like this environment may continue for some months, how to proceed in light of the new guidance and the changing legal landscape. Next slide, please. First thing I want to do is introduce the concept of having a COVID-19 plan and the importance of having it written out and having it be practical and not aspirational. In New York, a plan is required, and there's a template form on the New York Forward website, which Charlie will go into in more detail. This template form walks you through the issues, but it still takes a lot of thought and planning to complete. Sometimes we all have a tendency to write the world's greatest plan with all the bells and whistles that you could ever hope to have to show how seriously your company is taking the prevention of infection, responding to all different situations. But having a plan that you don't or can't follow can be worse than no plan at all. So it's really important to truth test and reality test the plan as you're considering it. A very important feature is to have a feedback loop. And this is because these plans are ever changing as the COVID environment and the legal requirements are ever changing, as well as guidance from health experts. So businesses need to have a periodic review of the plan with your core team. You can call them a response team or a task force for COVID matters, but your core team should meet on a periodic basis at least every 2 weeks And as you meet, they should discuss whether revisions or updates are needed to your plan based on changing circumstances. And when I say meet, I don't mean necessarily physically, however, we're all meeting these days. It's also very important to any compliance plan that there be leadership support from the top down. From owners to store managers on down, all those in a leadership role need to cooperate and lead in this culture of compliance. Everyone needs to lead by example. So a good example is to take opportunities to model compliance, obviously with face masks and all required PPE, but as much as you can. It means a lot to employees and customers to see leaders leading the way. Another feature that companies with a strong culture of compliance have is a method for self-enforcement. So a hotline for comments, for example, whether an email address or otherwise, a way to report issues and a method for discussion, say a town hall. And really an authentic solicitation of criticisms and comments about the plan and implementation. If you have open communication about the plan and any questions or ambiguities, that should result in stronger compliance by all. People may be unclear as to what something means, and if you're getting the same question from a number of employees, you probably need to clarify your communication. Sometimes this takes additional training, and you want to have a forum for understand what employees understand and what they have questions on. And then finally, there's the issue of audits and inspections. Some companies have this underway, others may want to consider it or consider expanding what you have in place. It's a way to determine whether your plan is actually being followed in your store, in your warehouse, in your office, or in your restaurant. So what's actually happening? All these things are things we highly encourage as you write, revise, and implement your COVID-19 plan. And why do these things matter so much? Next slide, please. Well, there is potential liability for the employer and the business that is selling products to consumers or opening their business and having consumers or customers come onto the premises and visit. There can also be enforcement by state and local officials. For the most part, we had seen this focusing on education in the initial months, but we can imagine a world in which this will become much more strict. And, as you know, violations are not a particularly sympathetic profile when things hit the headlines. There can be personal injury claims for infections, and we'll talk about this more. If these happen to employees, then workers' compensation would presumably cover this already. But if they're non-employees, such as consumers and customers, we can imagine the plaintiff's lawyers getting right on top of this. And they already have in a few instances in specific industries or services. The law will need to be made in the area, and it'll be interesting to see how it evolves, but obviously you would rather not be the plaintiff. There are public nuisance claims being brought that there are greater risks being presented in certain industries to certain employees. And public nuisance law is a very undefined frontier out there, which allows judges to have a great deal of discretion. And of course, these cases too are getting a lot of publicity. Then there's the possibility of false advertising and unfair competition. Many state laws that can affect consumer product manufacturers or retailers. In many states, a violation of an industry standard or the company's own announced policies can be a reason for an unfair competition claim. So this shows the importance of developing a plan that's practical and that you can and will implement. This doesn't mean that any mistake or foot fault will be a huge problem, but you should have a plan that you can actually accomplish. And of course, last on the list is that there are privacy and data security law violations potentially applicable relating to the collection of information and the dissemination of information. So that's an overview of many, many issues. And now I'm handing it over to my colleague, Charlie, for the next section.
Thank you, Kathleen, and pleasure to be speaking with all of you today. So I'm going to start with describing the basic elements of a COVID-19 preparedness and safety plan. So if we can turn to the next slide. These basics are in part based on state and local orders. If you have operations in multiple states, it's important to review the requirements in each of those states. After briefly discussing these basics, I will touch on the New York requirements. In addition to governmental orders, the basics of a COVID-19 plan are also based on what have been developing as best practices. So the basic elements of a COVID-19 plan include a few categories. The first category is training, such as making sure employees know what COVID-19 is generally, what are the symptoms of COVID-19, what precautions they should be taking to minimize the risk of contracting or spreading COVID-19, such as hand washing and disinfecting, making sure they are aware of social distancing requirements and how to social distance, and proper use of PPE or personal protective equipment such as masks and gloves. The second category is social distancing. So you have all heard the mantra by now that you should be maintaining a social distance of at least 6 feet. In your business, this may mean posting signs informing employees and customers to maintain proper social distance, or markings on the floor to indicate that customers maintain 6 feet from each other, physical changes such as barriers between workstations or physical distance between workstations, shields at checkout counters and separate in and out entrances and exits, and taped off directions. The third category of a COVID-19 plan is enhanced cleaning and disinfection. So you should be cleaning common areas frequently, such as 2 hours for high traffic areas. And for touch items, such as carts, counters, equipment used by employees that touch customers, for example, a hairstylist using brushes and sinks and the like, you should be cleaning those after each use. And of course, employees should be washing their hands often. The fourth category is personal protective equipment such as masks and gloves. Many states and localities require employees to wear masks, including New York. But many businesses are requiring employees and customers to wear masks as a best practice and irrespective of any governmental requirements. The fifth category is health screening. So there are two elements here. The first element, which is required in New York, is assessing whether employees have COVID-19 symptoms, and if they do, instructing them to stay home or to go home if they have already come into work, and implementing procedures that Catherine will discuss later in the presentation. The other element is temperature checks, which may be required in some states and localities, but not currently required in New York, which temperatures are either taken by the employee at home before work or by the employer before the employee shift. And then the final category of a COVID-19 plan is a staggered work schedule. So one way states and businesses try to limit widespread exposure and infection is to group employees by shift in order to isolate potentially infected employees and to better conduct contract tracing in the event an employee becomes infected with COVID-19. So let's turn to the next slide, and I'll now talk briefly about New York and the Bronx. So as most of you know, New York State reopened businesses in 4 stages, and New York was the last region to enter the 4th phase. And while New York City was the last region to enter the 4th phase. And while New York City entered the 4th phase this past Monday, it did so on a modified basis. There are still limitations on the businesses that can engage in indoor activities and other restrictions. For example, you may have heard that bars may not serve drinks to customers unless they also order a food item. So New York has specific industry summary guidelines which contain mandatory steps businesses must take in respect to the various elements of a COVID-19 plan that I went through in the previous slide, as well as best practices that New York recommends businesses to take. Businesses are also required to review and affirm that they have read and understand more detailed specific industry interim final guidelines, again, which lay out in more details elements of training, social distancing, cleaning, personal protective equipment, screening, number of people who can be in close spaces, and communication. In addition, businesses should be regularly checking the CDC and Department of Health website for additional guidance. Every business in New York is required to have a written COVID-19 plan, which calls a safety plan, and which must be conspicuously posted so employees and customers can see it. Now, while you don't need to send the plan to the government, you must retain the plan in case the New York Department of Health wants to see it. New York helpfully has a model plan that business can use for this purpose, but as Kathleen mentioned before, your plan should be tailored to fit your business while also including the provisions that are required by the guidelines that are applicable to your business. Also helpfully, on the last page of the model form is a useful list of resources such as the CDC website and Department of Health website that business owners should check regularly. Importantly, New York requires employers to provide their employees and contractors with masks and hygiene stations. If there's one thing you take from this slide, the most important thing to take from it is the last bullet: visit forward.newyork.gov. This is where you can find the guidelines, the model safety plan, the various resources, and other helpful information. I strongly encourage you to visit this site regularly. So we have prepared a few hypothetical situations that have practical real-world applications and how businesses can respond to them. The way this will work is we will present the hypothetical, and then we are asking that you all respond to our poll with your answer, and then we'll talk through the results of the poll, and we'll walk through how we would answer the question and some further information. So if we can put up the first poll, and I will read it as we put it up. So a store owner wishes to implement a policy that employees cannot come to work if they are experiencing a fever, such as a temperature above 100.4, chills, or other symptoms of a fever. So should the store owner, A, purchase touchless thermometers for store managers or another designee to perform daily temperature checks? B, require employees to take their own temperature before each shift and stay home if their temperature is 100.4 or higher? C, require employees to undergo a daily self-screening protocol that includes a questionnaire covering symptoms of COVID-19 without requiring daily temperature checks? Or D, none of the above, but rely on employees to stay home if the employee has a fever? And I'll give everyone a few moments to respond. Okay, so can we get the results? Envelope, please. Okay, so it appears that most people have chosen A, purchase touchless thermometers for store managers or another designee to perform daily temperature checks. So, I think that's a good answer. I think I would choose as the better answer C. And let me delve into that a little bit. So there are states that require temperature checks, but temperature checks are not necessarily required for New York businesses. As I mentioned before, New York has summary guidelines and more detailed guidelines for specific industries. The guidelines may be updated, and it's important to check the forward.newyork.gov website periodically for any updates, including whether temperature checks are required for the type of business that you are in. Many businesses are
Charlie, we lost you. Catherine?
Yes. Hi, Charlie. Okay, everyone, hang on one moment as we try to resolve this technical issue.
Hello, can you hear me?
We can.
I apologize. Are we, did we go on without me? Okay, so I don't know where we left off, but I was explaining that I think C is the better answer here. And the reason is because New York does not require employers to take temperature checks, and it's important that if an employer were to take temperature checks, that the employee be properly trained and wear personal protective equipment. But if the business does take temperature checks, then contactless thermometers should be used. So in New York, businesses must require employees to complete a self-screening assessment before their shift. And in general, these self-assessments must ask whether the employee experienced COVID-19 symptoms over the past 14 days, or had a positive COVID-19 test over the past 14 days, and or was in close or proximate contact with someone who had a confirmed or suspected COVID-19 case in the past 14 days. While a self-temperature check is not mandatory, some New York guidelines do recommend them, and you may ask employees to do one as part of your self-screening. So subject to any specific guidelines for your particular business, which again, you can find on forward.newyork.gov, I would generally answer C, but I might also ask employees to do a temperature check as part of their self-screening. So if we can go to the next hypothetical. Okay, so here, John, and if we can put up the poll as well. So John, a sales associate, recently traveled to Florida, and he returned to New York by plane yesterday and plans to come into work for his next shift. So should the store owner A, allow John to come to work, B, allow him to come to work, but only if the reason for his travel was to obtain medical treatment or other necessities, or to attend a funeral, C, require John to self-quarantine at home for 14 days, or D, require John to get tested for COVID-19 or absence of negative test, self-quarantine for 14 days. And I'll give people a moment to select their responses. Okay, can we show the poll results, please? Okay, so most people chose C, require John to self-quarantine for 14 days. And I agree with that response. So in New York, New York has a quarantine requirement that if you're traveling from certain so-called restricted states, you have to self-quarantine for 14 days. There are a lot of states on this list, and Florida is one of them. Individuals who have been in those states are required to self-quarantine for 14 days, as I mentioned, and individuals who fail to quarantine can be subject to penalties. In fact, travelers must fill out a traveler health form when flying into New York airports, so there will be a record of your flying into New York from a restricted state and your requirement to self-quarantine. And if you want more information about that, you can find it on New York's travel guidelines on New York's website. You can find New York's travel guidelines, traveler health form, and a list of the restricted states on the state's website for COVID-19 travel advisory. But it's important to note that this obligation is on the individual. A business is not currently required to enforce the self-quarantine or to confirm that their employees have not traveled elsewhere. So, you know, C is not required, but that said, businesses can take steps to avoid exposures, and it would be good practice to instruct employees to comply with self-quarantine orders if they have traveled to one of the restricted states. So let's turn to hypothetical 3, and let's put up the poll for hypothetical 3. Okay, so here, store owner has implemented a policy that each employee must complete a questionnaire before each shift to screen for symptoms of COVID-19. John, a sales associate, reports that he has had a headache in the past 24 hours. So should store owner A allow John to come to work but monitor him for any signs of COVID-19? B, ask follow-up questions to assess whether John's headache is explained by another reason other than COVID-19. C, require John to self-quarantine for 14 days. Or D, require John to get tested for COVID-19 or absent a negative test result to self-quarantine for 14 days. I'll give people a moment to answer that. Okay, can we get the responses, please? Okay, so it looks like we have a tie. Wow. So we have a tie between B, C, and D, which I am not going to read each one of those. Okay, so my answer here would be D. I think D is the better answer, and let me delve into that. So again, just to repeat, as I noted earlier, businesses in New York must require employees to complete a self-screening assessment before their shifts. And by the way, New York City has a simple model COVID-19 symptom screening tool that you can use for this purpose. And you can do the screening by phone or email or paper. Businesses are required to, and as a matter of good practice, the business should anyway have someone who is responsible for reviewing the self-screening response of employees, in addition to having someone to whom employees can report if they feel they have COVID-19 symptoms. New York businesses must document that they have reviewed the daily self-screening assessments. New York City also has a simple model log that businesses can use to document the daily reviews. So I think the best answer is D, right? Require John to get tested for COVID-19 or absent a negative test result to self-quarantine for 14 days. In general, businesses that are not in the business of providing medical advice should not be asking employees follow-up medical questions and making medical diagnoses. That really should be done by a medical professional. But when the employee is doing the self-assessment, they should be asked to report whether the symptom is new or not explained by another reason. For example, if it's allergy season and the employee typically gets headaches during allergy season, then that is not necessarily a symptom of COVID-19. But if it's new and not explained by another reason, then that symptom may be a symptom of COVID-19, and it may be appropriate to take precautions before allowing the employee to come into work. So it's important to educate, for employees to be educated on what COVID-19 symptoms are, so that they can properly respond to the self-screening assessments and report COVID-19 symptoms. Okay, let's go to the next hypothetical, and this is the last hypothetical that I will do before handing it off. And let's run the poll. So, so here, store owner has implemented a policy that each employee must complete a questionnaire before each shift to screen for symptoms of COVID-19. And store owner would like to maintain a record of this self-screening protocol, but is concerned it may run afoul of federal or state privacy laws. So should store owner A complete the questionnaire with each employee verbally without maintaining a written record of the responses? B, require employees to complete written questionnaires but destroy them daily? Or C, maintain the written questionnaire separately from the employee's general employment file, updated employee privacy policy, limited access, delete them when appropriate, and treat as confidential? And again, give people a second to respond. And envelope, please. Okay, so most people chose C, and I agree with that response. So again, as I noted earlier, screening may be done orally. So A is a possibility, but it can be email or paper as well. In addition, New York requires businesses to document that the screening assessment was reviewed. New York does not, as part of this process require that the actual assessment be retained. In general, in the United States, employees have a right to be notified as to the type of data their employer is collecting on them and what the employer is doing with that data. So businesses should update their data privacy policies to reflect the COVID-19 screening process. In addition, businesses should reduce their risk of holding personal health data of their employees. So businesses should make the assessments available only to those employees who need to know about them, such as the person who is responsible for reviewing the screenings. And if they do the assessment in writing, businesses should delete the information or anonymize it as soon as they can. So with that, I will pass the baton off to Josh Alloy to discuss the interplay with employment laws.
Thanks, Charlie. Catherine, you can go to the next slide. So I'm going to talk a little bit about some of the employment laws and regulations that sort of come into play in the new COVID world. I'm going to try to run through the legal stuff quickly so we can get to some more questions and hypotheticals and polls, because I think those are sort of useful tools. But briefly, what are some of the sources of legal issues that employers are potentially facing? One is OSHA. That is the Occupational Safety and Health law that requires employers to provide a safe and healthy workplace that is free from serious recognized hazards. So COVID-19 would be one of those. It also imposes record keeping requirements. And COVID-19 could potentially be a recordable illness if an employee is infected as a result of performing their work. There are no OSHA standards that are specific to COVID-19, but OSHA has provided some guidance. So by standards, I mean legal requirements, but there is some OSHA guidance that you can find on OSHA's website, and there's also the CDC guidelines, as well as obviously the state guidelines that Charlie just spoke about. Best practice generally is to follow CDC guidelines at a minimum, and obviously follow your state and local requirements as well. The Americans with Disabilities Act, the ADA, and state law counterparts, so New York State and New York City both have human rights laws that also protect individuals with disabilities. The ADA is sort of implicated in a few ways here. First, COVID-19 itself is not necessarily a disability, although it's possible someone who's infected with COVID-19 may be considered to have or perceived to have a disability by others. And so therefore, you want to make sure that individuals are protected from discrimination. The symptoms of COVID-19, so someone who is particularly sick, the symptoms may be serious enough to qualify as a disability, which would provide employees with certain rights to reasonable accommodations. Employees with pre-existing health conditions or disabilities may be entitled to reasonable accommodations in the workplace to protect them further from COVID. And the ADA is also sort of implicated, as Charlie talked a little bit about, with privacy and confidentiality, because a lot of the questions we're asking of employees and the information we're seeking involves personal health information and medical screening type questions and temperature checks. All of these could potentially implicate the ADA, although the ADA recognizes exceptions for pandemics and public health and safety. So this is why you're allowed to require temperature checks of employees. You are allowed to ask them questions about their medical symptoms, things you wouldn't normally be asking of employees or of customers for that matter, but you are allowed to do those. Title VII, which is the anti-discrimination law and state and local counterparts, we're seeing this implicated in a couple of ways. The first is national origin discrimination. So you can't discriminate against someone, including customers, based on where they're from. But you can discriminate in a way against people based on where they have traveled from, which is a separate issue than where someone originates from, where their national origin is. So putting in place screening requirements that say someone from Florida, or as I just learned, Maryland, unfortunately, has now been added to the list, which may include my vacation to your lovely state. You can discriminate, or someone coming from China, for example, you can put in place restrictions, but you can't say no one with of Chinese descent is allowed in the building. Obviously, that would be discriminatory. Same if it's against employees. We don't have it listed here, but age-related claims have also popped up with often well-meaning employers that are concerned about older workers being more at risk, but you can't exclude employees from the workplace simply because of their age. The FLSA, which is the Fair Labor Standards Act, this is wage hour law. So wage hour issues are also being implicated here, and claims are being brought by employees, including should employees be paid for time spent in health screenings or engaging in other safety measures throughout the workday? Are employers properly tracking and paying for time spent working remotely, particularly by non-exempt overtime eligible employees, if you have any of those working remotely? Many employers have been placing employees on furloughs, and there are issues that arise with furloughs. You need to make sure that you are doing those properly and not running afoul of wage hour law. And also expenses, business expenses related to remote work. Are employees entitled to reimbursement for added internet or computer or equipment costs? And then obviously Charlie just spoke a lot about the New York and New York City laws and orders that apply here. You can go on to the next page. Okay, so I know I covered a lot of this already. I'm gonna sort of fly through this quickly. The EEOC hasn't actually decided whether or not COVID is a disability, but certainly complications arising from it could be considered a disability, and employees who are more susceptible because of underlying health conditions may be entitled to reasonable accommodations. And what does all this mean? It means that if you have an employee who comes to you and says, I am not comfortable coming to work, or I have a medical condition that prevents me from coming to work or riding public transportation or whatever it is, you may be required to go through what's called the interactive process with that individual to determine, one, are they a qualified individual with a disability? And if so, is there some sort of reasonable accommodation that you may be able to provide to them that would still allow them to perform their job? Only if someone does have a disability, you still may be able to exclude them from the workplace if they're not willing to come in, for example, or there may be no reasonable accommodation that you can provide to them, but you do have to go through that process. In terms of a couple tips, one, you should not be excluding employees from working simply because they have a medical or health condition, even if that condition puts them at higher risk for severe illness. That does not give you license to sort of a blanket rule excluding older workers or anyone with an underlying condition. But you can, if you are concerned about high-risk employees, you can invite employees to come forward if they are uncomfortable returning to work, or invite them to request reasonable accommodations. Next slide. Quickly, workers' comp. Someone mentioned earlier, it is possible that an employee who develops COVID-19 or catches it at work may be subject to workers' comp and may be entitled to a claim through workers' comp, which would be the exclusive remedy of that individual. New York has issued some guidance that an employee who gets COVID-19 at work is more likely to be eligible for benefits, but not necessarily. Other states like California have passed laws that create a presumption that if you catch COVID-19 while working, that if you get COVID-19, it's presumed that you got it at work. That's not the case in New York, but the point is here that employees may have workers' comp claims if they get sick after working. Next slide. Okay, leaves of absences and accommodations. So employees may be entitled to take unpaid leave under the Family and Medical Leave Act, or a state law equivalent. This usually gives people up to 12 weeks of unpaid leave. But for the first time, we've got a federal law that provides some form of paid sick and family leave to individuals. This is the Families First Coronavirus Recovery Act that was passed way back in March or April now. And that runs through December 31st. It applies to probably all of you, which is going to be smaller employers with fewer than 500 employees. If you have less than 50 employees, you might be able to exempt yourself from the family leave aspect of this, but there's also a paid sick leave aspect. So everyone can get up to 80 hours of paid sick leave if they are sick with COVID, or if they are quarantining under a state or local order, or if they can't work because they need to provide childcare. There's also up to 12 weeks of family care leave. This is paid at a lower rate, generally capped at $200 a day, and this is only to care for, I know it says here a sick family member, it's really only to care for a child whose school has closed. We've also got, New York has its own paid sick leave law, so in New York City, employees already have entitlement to paid sick leave. There was also something passed at the beginning of the pandemic in New York State that provides some additional paid leave to employees who are under a order of quarantine. That is an official written order from the Department of Health or the state or the city, not just because someone is self-quarantining or has been directed to quarantine by their doctor. And the ADA, as I talked about, may require as a reasonable accommodation that you allow people to go out on unpaid leave. All right, let's get to some more hypotheticals and questions. So if you could put up the next poll. Store owner has implemented this is the general hypothetical. So a store owner has implemented a policy that all employees must wear face masks at work. And the store owner has provided face masks to all employees for this purpose. There is a local shelter-in-place order. The store owner has not yet opened its doors for customers to come inside the store, but they are doing curbside pickup and delivery. 2 employees sit outside on the curb and interface with customers who have ordered things online or by phone. And there's some sales employees inside the store who are interacting with each other to help find the products that are ordered, package them together. Once the products are packaged and invoiced, the employees deliver the products to the door for the curbside employees to pick them up and distribute them. So this is sort of our general overlay of the hypo. All right, so specific questions. If we could put up the poll. John is a sales employee and he objects because he has a medical condition that inhibits, restricts his ability to breathe while wearing a mask. He asks for an exception to the mask requirement, and he is the only employee who has asked for an exception, which means that every other employee would be required to wear a mask, but he is asking that he not be required. What should the store owner do? Allow John to work without a mask because he's got a justifiable reason. Refuse to let John work without a mask. Ask for documentation of his medical condition, and in the meantime, refuse to allow him to work without a mask, or ask for documentation of his condition, but in the meantime, let him continue working without a mask. I'll give people a few seconds to plug in their answers. All right, if we could go to the results. Well, you guys are good. I agree with the majority of you who voted. We should be asking John for documentation of his condition. He has stated that the reason he can't wear a mask is a medical condition. This should trigger a possible interactive process under the Americans with Disabilities Act. You are allowed to ask an employee who has requested a reasonable accommodation for some form of medical documentation that would support that request. But in the meantime, you do not have to allow him to work without a mask. That is a legitimate rule. Put aside whether New York City or New York State requires masks. Even if they did not, you as a store owner could, or a business owner can require your employees to wear masks at all times, subject possibly to legitimate medical reasons. All right, let's go to the next question, and if we could pop up this poll as well. Question 2, all right, so John submits medical documentation. It certifies that he has asthma and that precludes him from wearing face coverings for an extended period of time. Now what should you do? Let him work without a mask. He's provided you medical documentation. Tell him, I'm sorry, but I can't allow you back to work. Look for somewhere else, another position in the company that might allow him to work from home or work in a way that doesn't interact with anyone, or place him on a leave of absence. Put in your answers. All right, let's go to the responses. I think we've made these too easy for you. It looks like the majority have selected C, look for another position in the company that would allow him to either work at home or work without infecting with it, interacting. I agree. Basically, you should be exploring, is there something we can do that will let John keep working? Whether that is finding him some other work to do or another position, figuring out a way to let him work from home, figuring out a way to sort of quarantine him in the corner so he doesn't have to interact with anyone, some way so that you can balance your legitimate needs to protect the health and safety of your employees and the public, while not sort of just refusing to allow John to work. I saw something pop up that said, what if it's a pizzeria? And the answer is, you explore, are there reasonable accommodations? And if there are not, then you can rightly tell John, look, the reasonable accommodation I'm willing to offer you is you can go on a leave of absence. You can go on unpaid leave until it's safe enough for you to return to work without having to wear a mask. But right now, my mandate is I'm not going to operate this pizzeria or this store unless everyone has a mask on at all times. John's legitimate medical condition and disability does not trump health and safety in this instance, right? That's not always the case. In a non-COVID world, if John's condition is that he can't, he's got an issue, so a physical ailment, and there is some reasonable accommodation that you could give, you don't get to say, well, health and safety trumps that. There you would have to further explore things with him. But here, the ADA doesn't really trump masks for the most part. Okay, let's move on to the next hypo. All right, Neil has objected. So this is sort of the same, another employee, Neil, has objected that the mask that's been provided to him interferes with his facial hair, and keeping his facial hair is in furtherance of his legitimate religious beliefs. What do we do? Do we let Neil keep working without a mask? Do we refuse him, just like we ultimately may refuse John if it's a pizzeria? Do we look for another position in the company that would allow Neil to work at home or work without interacting? Do we put him on a leave of absence, or do we allow him to wear a different mask or face covering of his choice? Let's go to the answers, and I'm trying to fly through these as quick as possible because I know we're running out of time. All right, allow him to wear a different mask or face covering of his choice. That's right. So there's also a similar reasonable accommodation type requirement for sincerely held religious beliefs. And the scope of this is not quite as broad as the Americans with Disabilities Act, but it does require you to explore if there is some reasonable alternative. Here, ideally, there would be some other form of face covering that serves the purpose of protecting Neil and the public, but doesn't quite interfere with his facial hair in the same way as the mask that you provided does. But ultimately, if there is absolutely no face covering that would work, you would not have to accommodate Neil either, but you certainly should explore if there's something that can be done. Okay, let's move to the last hypo. Okay, someone has complained, Darla has complained that there's a screening questionnaire that has to be filled out every morning. And this face mask policy is a pain, and it requires her to spend time filling out the questionnaire and cleaning her glasses, which are constantly fogging up because the mask that the employer provided, isn't ideal. What should you do? Do you have to pay her for any of this time? Should you pay her for the screening time? Should you pay her for the time spent cleaning her glasses? Should you pay her for both, or do you not have to pay her at all for any of this extra time? What do you all think? All right, let's go to the results. Pay her for nothing. Interesting. All right, and I may not have given people enough time, and I see that statistically not significant. So the best answer is probably pay her for both. The law is still developing here for what time you have to spend, particularly extra time before a shift, filling out a questionnaire. But I think, without going into too much legalese, that paying employees for the time spent going through a questionnaire, as well as any extra time they may spend adjusting their safety gear during the day that you, the employer, are requiring, should be considered work time and compensable. All right, and the last slide deals with wage and hour concerns, and I think I really already talked about these at the very beginning. So with that, I am going to kick it over to Catherine.
So I'm conscious of the fact that it is past the top of the hour. We're happy to stay on and continue if folks would like that. Lisa, what are your thoughts on that?
I don't have a problem if our participants want to stay on and ask direct questions. If they feel they cannot, I posted a lot of questions in the chat, and we will make sure to get those questions answered. But if you'd like, we can continue answering some of these questions. And
sorry to interrupt. We do have one brief section first. We have 2 more hypotheticals on responding to exposures that we are happy to continue to run through.
absolutely, I would love to hear that.
Yes, so we will continue then, and the slides, if I'm correct, will be distributed so that if anyone has any questions that has to drop off now, they can follow up with Lisa. So with regard to exposures in the workplace, there are several considerations that employers and businesses have when an employee tests positive for COVID-19 or when responding to employee COVID-19 exposures in the workplace. So first, there are concerns with respect to notification, reporting, and contact tracing. Employers have to make decisions about whether to notify both customers and then separately whether to notify other staff and employees. And when making decisions about what employees to notify, it's very important to keep in mind state and local guidance. So New York State, for example, has requirements related to employees who have been in close contact with a person who has COVID-19 for a prolonged period of time staying home from work. So close contact for a prolonged period of time, in this case, under New York State law, is within 6 feet for 10 minutes or more. An employer also must understand requirements to notify local health authorities. So under New York State guidance, that requires that state and local authorities be notified immediately if test results are positive. And in New York City, guidance has said that local authorities should be notified by emailing the New York City Test and Trace Corps. However, an employer also has to balance these notifications with privacy requirements to make sure that employee confidentiality and customer confidentiality is maintained. Many states and localities, including New York State, have heightened cleaning and disinfecting requirements in stores or areas of a workplace where an exposed or ill employee has been. And then, as we've already discussed, there are additional considerations with relation to workers' compensation for employees who are sick. So we're going to quickly run through a hypothetical. Despite its best efforts, one of store owner's full-time employees, John, a cashier now providing curbside delivery for customers, reports on a Wednesday that he has tested positive for COVID-19. John most recently worked the weekend, but started feeling unwell on Monday. When he was out most of Saturday and Sunday dropping packages into customers' car trunks, he was in the store with other colleagues for breaks, lunch, and to pick up customer orders. Some orders require 2 employees to carry. Store owner has a record of customer pickups during John's shifts. Store owner pays its managers on a salary basis with full benefits, including sick leave. It pays stockroom clerks and cashiers on an hourly basis without any sick leave. As a result, the hourly employees do not earn income if they're out sick. Store owner requires employees to self-certify each day before they come to work that their temperature is below 100.4 degrees Fahrenheit and that they have no other symptoms and have not been in close contact with anyone who has been diagnosed with COVID-19 or is exhibiting symptoms. John self-certified that he was symptom-free on both Saturday and Sunday. So for the first question for this, if we can pull up the poll. What steps should store owner take in response to John's report that he's COVID positive? Should they A, bury or in-store areas where John spent more than 10 minutes and begin deep cleaning those areas immediately? Should they B, notify all employees who work the same weekend shifts as John that a fellow employee has tested positive for COVID-19 and require them to self-quarantine for 14 days or undergo COVID-19 diagnostic testing before returning to work? C, notify public health authorities? D, advise John that he may return to work in 10 days provided he feels well at that time? Or E, none of the above? So we'll give folks a moment just to answer. And then if we can show the responses. So most of you chose notifying all employees who work the same weekend shifts as John. And I think the best answer here is actually E, none of the above. And the reason that that's the best answer is that a comprehensive approach that combines many of these responses is really the best approach here. So in particular, discussing the notification of other employees, most of the best recommendations regarding notifying other employees focuses on notifying employees who have been in close contact for a longer period of time. And it can sometimes be challenging to identify which employees those are, because an employee may not remember everyone who has been within 6 feet for 10 minutes or more, or an employee may have been in a shared space, say a lunchroom, with other people, and other people may have come in and used that space and touched items immediately after. Unfortunately, this is one of the challenges of running a business in this COVID-19 environment, is that you have to balance between, on the one hand, potentially losing 2 shifts of employees who could be out as long as 2 weeks, and protecting the health of your employees. So I think that taking the option of notifying all employees, there's probably a more moderate approach of notifying just the employees that he had close contact with, to the extent you can figure that out. The other options, though, New York State does require cleaning and disinfecting workplaces if an employee is confirmed to have COVID-19. John would be required to stay home for a period after the positive test. And as we discussed, New York does have requirements to notify public health authorities. Then the second question, if we can get the poll up. What should store owner do in connection with contacting its customers regarding John's COVID positive test? Should it A, use any method of communication to contact customers who may have interacted with John and pass along all relevant information to any recipient of that communication? B, update its privacy policy and ask customers' consent to contact them regarding the employee's positive test? C, only contact customers via email and describe why you are contacting them? Or D, none of the above? So if we can put up the responses. So it looks like people generally chose C. And I think actually the best answer here is B. So there are two things that need to be considered here when you're thinking about privacy during the time of COVID. You need to think separately about the privacy of your employees and the privacy of your customers. On the employee side, you will have to update the employee privacy policy, which is only included in option B. On the customer side, though, you should be very careful about contacting customers regarding employees' positive tests. In the United States, you likely do not have to get customers' consent today, but there are bills that are pending in Congress, and some of those would quantify this as contact tracing type information, which could require explicit consent. Just to note, different locations have different privacy regimes, some of which may be more or less stringent than others. But across the board, option B, updating the privacy policy and asking for the customer's consent is probably the best option. And with that, I will turn this back over to Lisa for any closing remarks.
Thank you so much. Hold on one. Do you release my video? Oh, there we go. I want to thank Arnold and Porter. There were a lot of questions that I put on the side that have been asked of me, so I will put them, we will type them up, allow Arnold and Porter to answer them and send them out. A recording of this entire presentation, which is eye-opening. You know, there's a lot of stuff here that I was unaware of, that I'm sure a lot of people on this webinar were not aware of. So I cannot thank you enough to partner. Is there any immediate questions that you would like to ask that Arnold and Porter can answer for you now? Also keep in mind, as I said in the beginning of this presentation, Arnold and Porter has generously offered a one-on-one consult with anyone that needs to have a direct conversation. They are the experts. Just contact us at helpdesk@bronxchamber.org and we will make sure to put you in contact with the appropriate experts. And with that, I believe we have no further questions. Thank you, Arnold and Porter. Thank you to the Bronx Coalition Group. Mike, thank you. I see you're wearing your mask. That's exactly the way you should be doing it. I'm breaking the rules, so too contrary to the way we're handling it. I know one of the questions that have come up is the differences behind, between store owner retail versus office buildings and offices. So I'm curious to know the answers to that, but we will allow everyone to go about their day. Again, I thank you. Mike, do you have any closing words?
No, just thank you to Arnold and Porter. Thank you to the Bronx Chamber and all of our partners. This has been very informative, and I hope it continues to put us on the right track for reopening. And thank you again, Lisa, for all of your work.
Thank you. All this will be found on our YouTube channel. And again, any questions, by all means, ask. Thank you again, Arnold and Porter, and look out for our next webinar. Everybody have a fabulous day.
Thank you all.